So moving on to today's e-forum, our presenter is Lara Radik. She'll be talking on geo-employment issues amidst the COVID-19 pandemic. Lara graduated from the Australian National University with a double degree in Law and Asian Studies and is a special counsel in Newell's workplace advisory team, focusing on workplace and industrial relations and workplace health and safety. She has over 13 years post-admission experience, advising in these areas across a wide range of industries and client types. Without any further ado, I'll hand over to Lara to get going. Thanks, Lara.
Thanks, Peter. I'm just trying to get my screen up so that everybody can see the slides. Hopefully you can all see them now. So without any further ado, I will launch away into the presentation. So I'm just having trouble getting my slides to move. Okay, so excellent. So I just need to use my mouse rather than my arrow. Excellent. So first issue I'll be touching on is what an employer needs to do if an employee tests positive for COVID-19. Hopefully none of you will be faced with this scenario, but I thought it's best to lay it out there just in case it does come across your desk. Now, employers are obliged to notify the health department in their state or territory. And depending on the severity of the condition, they may also be obliged to notify the work health and safety regulator. So if the infection occurs in the workplace and if a person dies or is admitted to hospital as a result of the infection, then ordinarily you would be obliged to notify it as a notifiable incident. However, Queensland is the only state in Australia which has said that they do not want to be notified of these incidents. So don't bother to notify Workplace Health and Safety Queensland, but if you're in another state or territory, you may well have to notify your local regulator. Should go without saying that employees who have tested positive for the virus cannot and should not attend the workplace. The employer can direct the employee to stay away from work and to obtain a medical certificate before they return. Now, the current guidance from the safety regulators, and obviously this does change from time to time, but based on the current guidance, an employer is to inform co-workers about their possible exposure to COVID, but to otherwise maintain the confidentiality of the person who has tested positive. So employers should also be advising their employees to seek immediate medical advice if they develop symptoms or they're otherwise concerned about their health. Full-time and part-time employees who contract COVID are entitled to paid sick leave for the duration of their incapacity for work. And obviously an employer is entitled to the usual medical certificate to evidence their incapacity. So if an employee is required to self-isolate but otherwise isn't unwell, they would ordinarily not be entitled to sick leave. So if their work is of a type that can be performed remotely, then ideally an employer should facilitate those remote work arrangements. If the work can't be performed remotely, and obviously there's a lot of work in the mining sector which simply has to be performed on site, then an employer might consider allowing the employee paid annual leave, unpaid pandemic leave, which is for a period of 2 weeks unpaid, or paid personal leave. Now, as I've said, if the employee is not unwell, then they're not entitled to paid personal leave, so it would be at the discretion of the employer whether they grant that. Now, schools or childcare centres, based on the announcements that we've had in the last few days, it looks as though schools are going to be back up and running as usual in the next few weeks. But that's not to say that there won't be further closures if there are infections amongst staff or students. So the guidance from the Fair Work Ombudsman is that if a school or childcare centre closes unexpectedly and on short notice, then an employee can access their carers leave for a short period until they can make alternative care arrangements. But extended school closures of the type that we've seen for the last couple of months aren't unexpected and aren't on short notice. So there's no entitlement to carers leave in those circumstances. Now, home confinement orders have been rolled out in most states and territories. Thankfully, some of them are now easing, but they haven't eased fully in relation to return to work. So in the context of work, individuals are generally permitted to leave their home only if their work is of a nature that cannot reasonably be performed from home. Now, the responsibility here is on individuals, not on businesses, to ensure compliance with the home confinement orders. So it's not as though a business will be fined if an employee takes it upon themselves to go to work in contravention of a home confinement order. That being said, I am aware of some employers who are taking the risk of encouraging employees to come to work, and I would say you should exercise extreme caution if the work is in fact of a nature that can be performed from home, and the only reason for the encouragement to come to work is so that employees can be properly supervised and make sure that their productivity is at the levels employers would like them to be. Now, if an employee is planning to annual leave to travel overseas, at the moment there's obviously a restriction on any overseas travel for Australian citizens, but you may well have employees who are foreign citizens who might need to return home for a family emergency or whatever it might be, and likewise the overseas travel restrictions may ease in the next 12 months or so. If there is still a mandatory quarantine requirement upon a person's return to Australia, then Section 88 of the Fair Work Act may well assist an employer in refusing an annual leave request in those circumstances. So if an employee is going to have to quarantine for 14 days on their return from annual leave, an employer could argue that operationally we simply can't have the employee away from work for that length of time. Or alternatively, an employer may well say that we'll approve the annual leave request, but only if you agree to take annual leave for the duration of your 14-day quarantine period. Now, obviously, if an employee is required to travel overseas for work, they'll be entitled to full pay for any period they have to spend overseas or in quarantine. But from my understanding, there is very little overseas work happening at the moment. So work health and safety. Work health and safety laws require employers to take reasonably practicable steps to ensure the health and safety of their workers and others at the workplace. That requires an employer to undertake a risk assessment, taking into account all of the relevant information from health authorities, as well as the prevailing circumstances at the workplace. And the idea behind it is to identify risks and to do what's reasonably practicable to eliminate or minimise all of those risks. Now, in light of what's known now about community transmission of coronavirus, directing workers and other people to stay away from the workplace may well be the only available means of eliminating or minimising the risk of the virus spreading. That might change as these restrictions ease and as the medical guidance changes over time. Where the work can't be performed remotely and where you can't exclude people from the workplace, then obviously the direction to stay away isn't going to be reasonably practicable, and you won't be required to make that direction. What you will be required to do, however, is to look at what other measures need to be in place in order to minimise the risks that remain in the workplace. So it might be things like implementing an A shift and a B shift, so that if one employee tests positive, only the members of their shift are at risk of infection and not the members of not every member of the workplace. And also, common sense things like regular cleaning, making hand sanitizer available, discouraging employees from using public transport, all of those sorts of things. Now, those work health and safety obligations don't end just in the traditional workplace. So if an employer has directed or permitted employees to work from home, those work health and safety obligations also apply in the home workspace. So employers need to do, again, what's reasonably practicable to ensure that home workspaces are without risk to health and safety. And that might include performing a risk assessment of home workspaces. Now, it's obviously going to be quite difficult for an employer to conduct a risk assessment in the home workspace if they have hundreds of employees. They're not going to be travelling to every single employee's workspace. What we've been recommending instead is a sort of a tick a box sort of risk assessment that's completed by the employee in their own home workspace. They can then scan it and send it back to their HR officer. And if there's any red flags, obviously the HR officer will chase it up. But if everything seems to be business as usual, then it simply forms part of the personnel record. Obviously, incident reporting protocols may be different when people are working from home as compared within the workplace. So it's important that you ensure that those incident reporting protocols are maintained and accessible to people who are working from home. And finally, in terms of maintaining employees' psychological wellbeing, not just physical wellbeing, it's really important that we all continue to stay in touch with our workers on a regular basis. So if your business has suffered a downturn, one of the options that you may be looking at is forcing employees to take leave. Now, under the quarrying award and mining industry award, an employer can direct an employee to take annual leave if they have an accrued balance in excess of 8 weeks or 10 weeks for a shift worker, and genuine attempts to reach agreement about the taking of leave have failed. The same applies for the black coal mining industry award, but the employee must have an accrued balance in excess of 10 weeks or 12 weeks for a shift worker. The direction must not result in the employee having a remaining annual leave balance of less than 6 weeks. And forced annual leave during a shutdown period is also permissible, although a notice period of at least 28 days to about 1 month is generally required. And that applies under those awards in your industry. Pursuant to the Industrial Relations Act in Queensland, an employer can also direct an employee to take at least 4 weeks of long service leave, provided that genuine attempts to reach agreement about the taking of long service leave have failed, and the employer has provided at least 3 months written notice of the requirement to take the leave. So another option that you might be exploring is standing down employees without pay. Section 524 of the Fair Work Act is the relevant section which allows it. It does only allow it in very limited circumstances, which are set out on this slide. So it only occurs during a period in which an employee cannot be usefully employed due to a stoppage of work, not a slowdown, but a complete stoppage, and for a cause beyond the employer's control. Any decision to stand down employees without pay due to financial downturn is likely to be unlawful, because the authorities suggest that a decision to stand down where your business is doing poorly involves an active decision on the part of the employer. It's not like other circumstances where the cause is completely beyond the employer's control. So circumstances where it will be beyond the employer's control are where entire industries have been shut down, so pubs, restaurants and so on, obviously beyond their control that those government mandated shutdowns have been put in place. Another circumstance is where, for example, critical parts cannot be sourced for a manufacturing process, and manufacturing has to cease in those circumstances. So the other thing I've put down there is that Jobkeeper enabling provisions, if they apply to your business, they may well help out, and I'll talk about those shortly. So making staff redundant is another option, and it's critical to ensure that if you're pursuing this option that you make sure that you meet the definition of a genuine redundancy under section 389. If you don't meet the definition of a genuine redundancy, then your employees are likely to make an unfair dismissal claim, particularly if they're under the high income threshold. So the requirements of section 389 are that the employer demonstrates that the job is no longer required to be performed by anyone because of changes in operational requirements. In the current economic climate, if you simply can't afford to continue employing all of your employees, you're probably going to tick that first box. You'll probably quite easily be able to demonstrate that you simply no longer have the requirement for as many staff as you previously had. Second box is you need to comply with any consultation requirements. Those are generally set out in the applicable award or enterprise agreement. And it's really important to bear in mind that the consultation requirements are prescriptive. They do require written notice to be provided, not just a casual chat between employer and employee. And if you don't meet the strict requirements for consultation, then you could fall foul of the genuine redundancy rules and find yourself facing an unfair dismissal claim. And finally, the employer has to demonstrate that it would not have been reasonable in all the circumstances for the person to be redeployed within the business or within an associated entity. And one of the common missteps that we see in relation to that particular step in the process is an assumption that an employee should only be offered a job which the employer thinks the employee would like or would likely accept. the reality is that you have to offer to the employee every available position that they're capable of performing. So if you're making a secretary redundant and you have a CFO position available, you're not obliged to offer the secretary the CFO position because they simply don't have the qualifications to perform the requirements of that role. But if the inverse applied, you're making the CFO redundant and you have a secretary position available, you would have to make the offer to the CFO. In all likelihood, they would decline the offer, but the requirement is that you make available to them all redeployment opportunities within the business and associated entities. And finally, if you do have to make staff redundant, you should also bear in mind Section 120 of the Fair Work Act, which enables an employer to apply to the Fair Work Commission for a reduction in the amount of redundancy pay that would otherwise be payable. There haven't been, surprisingly, there haven't been that many applications under this section in recent times, but I would have thought that the prospects of an employer succeeding in this sort of an application would be greatly enhanced at the current time, given that many employers are in genuine financial distress, and the payment of a significant redundancy payment is likely to affect their ability to A, continue operating, and B, continue employing their other valued staff. So alternatives to redundancies and stand downs. The principal alternative is to implement reductions in work hours or salaries. Generally, the two go to hand in hand. So if you want to reduce salaries, you also should be considering a corresponding reduction in work hours. That being said, it's not always the case where employees are earning significantly higher than award minimum amounts. Some employers are reducing salaries and requiring employees to continue working their usual hours. That does tend to go down not very well. Employees obviously don't want to continue working for less pay, but if that's what it comes to, then you may well be able to negotiate that if as I say, they are well above award minimums. Now, some modern awards have been varied to include COVID flexibility provisions. Unfortunately, the Mining Industry Award, Black Coal Mining Industry Award and Quarrying Award are not any of the awards which have been altered. Pardon me, the Quarrying Award has been altered to include the COVID-19 flexibility provisions. So have a look at those flexibility provisions. They do differ from award to award, but generally speaking, they allow employers to look at things like reducing work hours. Now, the Jobkeeper enabling directions, which I'll talk about shortly, also allow reductions of work hours in certain circumstances. But unless you have one of those COVID-19 flexibility provisions applying to your business or a Jobkeeper enabling direction applying to your business, in any other circumstance, you cannot unilaterally alter an employee's salary or work hours. Any attempt to do so unilaterally will be a breach of contract, and so it's really critical that you consult with your employees, reach a genuine agreement, and then reduce that agreement to writing. So, Jobkeeper payment, topic of the month, everybody's wanting to know about it. The Jobkeeper payment is paid at a rate of $1,500 gross per fortnight. It's currently capped at a 6-month period, but that may well be reviewed if the economic climate continues the way it is at the moment. Eligible businesses include any business, company, partnership, trust or self-employed individual with the annual turnovers that I've set out below in that slide. So for large businesses with a turnover of over 1 billion, they have to have a 50% reduction. And for smaller businesses, although still big in some circumstances, with a turnover of less than 1 billion, have to demonstrate a 30% loss of revenue. In order for your employees to be eligible, they have to be at least 16 years old. They also have to be an Australian citizen or the holder of certain types of visas. They have to have been employed by an eligible employer as at 1 March 2020, although it can be the case that they have been terminated or stood down and rehired since 1 March. They have to be full-time, part-time or long-term casual, and they have to be not already receiving the Jobkeeper subsidy from another eligible employer. So people who have casual employees who work for multiple businesses, those casual employees have to make an election as to which employer they want to receive the Jobkeeper payment from. So applying for the payment is done via the ATO website. If you're nominating for the Jobkeeper scheme, you have to employ each eligible employee that you've nominated them to receive the payment. And you then have to ensure that all eligible employees are paid a minimum of $1,500 gross per fortnight. And that's regardless of whether they ordinarily receive something less than $1,500 prior to the Jobkeeper scheme. Now, Jobkeeper enabling directions, these are now included in the Fair Work Act, and they're designed to ensure that people stay in employment throughout this pandemic, and to facilitate the running of businesses while people are relying on these Jobkeeper subsidies. So in certain circumstances, a stand down is going to be authorised. So it has to be after 9th of April, which is fine, we're already beyond that date now. But once a direction is made, the employer can say that an employee has to not work on a day or days that they ordinarily worked previously, or that they have to work a reduced number of hours as compared with their ordinary hours. They have to be able to demonstrate, that is the employer, that the employee can't be usefully employed for their normal days or hours due to the pandemic. So it can't simply be that I don't like this employee and I want to reduce their hours. You have to actually have evidence that it's due to the pandemic. And during the stand down, obviously the employer has to continue to pay the employee's salary. That might be the minimum of $1,500 gross per fortnight under Jobkeeper, or it might be something more based on their ordinary salary amount. Oh, sorry, I've gone too far forward. So another Jobkeeper enabling direction which can be issued is to require employees to perform different duties, or to perform duties at a different location. Now again, the direction can only be issued after the 9th of April, which isn't a problem now. But some of the things that need to be kept in mind is that the different duties that you're directing an employee to perform have to be safe, and the employee has to be reasonably capable of performing the duties. And in addition to that, the duties have to be reasonably within the scope of the employer's usual business operations. So for example, if you have a person who's ordinarily working as an engineer in your business, and you don't have any engineering duties available for them at the moment, you can't then direct them to perform duties homeschooling your children, because that's not within the normal scope of your business operations. But you might be able to, for example, direct them to perform administrative work in the business because of the lack of engineering work available. And likewise, directing an employee to perform work at a different location, it has to be safe that they perform work at that location. It has to be not a distance too far for the employee to travel in order to get to the location. And again, the location has to be reasonably within the scope of the employer's business operations. So same example of homeschooling, you can't require an employee who usually works in your office to go to your home and start performing the duties at home, because it's not in your home, as in the employer's home, not the employee's own home, because that's not in the normal scope of your business operations, having your employees sitting at home doing that work for you. Now, there's a couple of things here that can be requested. So strictly speaking, although they fall under the Jobkeeper enabling directions, they're not in the nature of a direction. So Jobkeeper eligible employers can request eligible employees to work on different days or at different times compared to their ordinary hours. And an employee has to give genuine consideration to that request and can't unreasonably refuse the request. If they have family or carers responsibilities, then they may well have a reasonable basis for refusing it. But as I say, they do have to consider it and ideally comply with the request. Jobkeeper eligible employers can also request that a Jobkeeper eligible employee take paid annual leave. And the provisions do allow for that leave to be taken at half pay if the employer and employee agree to that. And again, the same rule applies in terms of an employee having to give genuine consideration to the request and only refusing the request in reasonable circumstances. Now, finally, the Fair Work Act specifically says that the giving of a JobKeeper enabling direction will not amount to a redundancy. And that's really important because up until now, if an employer has unilaterally reduced an employee's hours of work or fundamentally altered an employee's role, then a constructive dismissal and redundancy occurs, and the employee can say, well, you no longer require my role to be performed by anyone, therefore I want you to pay up my redundancy entitlements. Fair Work Act clearly says that is not what's going to happen if you make a valid JobKeeper enabling direction. So that's it for me for today, but I'm more than happy to take some questions if anybody has any.
Thanks, Lara. As people furiously type their questions, I hope there's one or two there already, but I'll kick it off with our industry. I guess there are a lot of junior exploration companies out there who don't have an income from any kind of operation, so their income comes from capital raises and the like. Now, there'll be quite a few companies out there who, I guess, are well funded, or at least have enough funding to maintain a workforce, if nothing else at the moment, for some time. Obviously have enough significant cash reserves. What can they or can't they do in terms of their workforce if they can't get out in the field? Can they start laying people off even though they've, the company itself's not in trouble?
So based on what you're saying, are they going to have any reduction in turnover?
Well, exploration companies won't have an income as such.
Right.
They'll be only getting money through capital raises.
Yes.
And obviously at the moment they're not going to be able to raise too much capital if they can't do any work. But
Yes.
if they do have significant cash reserves,
Yep.
enough to certainly maintain staff for a couple of years, what can they do, and what can the staff expect?
Well, there are two principal options. One is if they have completely stopped work because there is no capital raising and therefore no exploration happening, then they could stand down employees without pay. It is critical though that there be a complete stoppage of work rather than a slowdown of work. So that may not be an option for everyone. The other option is they can decide for operational reasons that we are going to make changes to our business, including redundancies. So even though they may well have capital reserves which would allow them to keep those employees on, there's no imperative for them to do so if their operational decision is that the interests of our business are best served by cutting costs at this time, and cutting costs will include redundancies.
Okay, thank you. Next question, I have one from Cam Schubert. It says, hi Lara, you mentioned the unpaid pandemic leave of 2 weeks. Is this limited to 2 weeks? If so, what happens after the 2 weeks? i.e., do you need to pay the employee?
Yeah, so the unpaid pandemic leave is limited to 2 weeks, as in that's the entitlement that an employee has. An employer always has the option to extend the leave beyond that. And the reason why the unpaid pandemic leave has been introduced is because there was identified a gap in employee entitlements. So employees who didn't have accrued annual leave couldn't rely on sick leave, for example, if they're not unwell, but they've been told to self-isolate for 14 days. So this 14 days of unpaid leave was created so that employees who are directed to self-isolate don't get forced into a position of being fired or having to resign from their job in order to comply with the isolation requirements. So if you have an employee who has to self-isolate for longer than 14 days for whatever reason, then my strong advice would be to extend the period of unpaid leave. As I say, it's not an entitlement that the employee has, but the only other option is to force the employee to take paid leave if they have any, or consider other options which, as I say, the fear was that people might go around terminating people's employment, and I don't think that being absent due to a self-isolation period is really a valid reason for dismissal. So I think you really need to do everything possible to allow the employee to take whatever leave is required before they're able to return.
Okay, thanks, Lara. Mark, I believe you have a question.
Thanks, Peter. Lara, thank you for that excellent presentation. For those employees that are on the call today, I'm just wondering if you could talk about some of the key observations that you've made so far during the pandemic where employees' rights seem to have been not followed very well by employers, and what actions that employees can actually take if they think they've been unfairly treated.
Yep. So one of the most common pitfalls I'm seeing at the moment is a failure to consult properly in accordance with the award or enterprise agreement requirements. And if there has been a failure to consult in that way, then there are a number of options available to employees. One, if your employment has been terminated, you may be able to think about a claim through the Fair Work Commission. Or if your employment has not been terminated, you can still consider a claim through the Fair Work Commission based on a breach of an award or breach of an enterprise agreement. Both of those actions are probably going to somewhat sour your relationship with your employer if that relationship hasn't already ended. But if you approach it correctly, it may well be a means of bringing your employer to the negotiating table, because some employers simply don't realise that they haven't complied with their requirements, and alerting them to it will sometimes bring them to the negotiating table. One of the other things that we are yet to see, but I expect we will see, is employers using the Jobkeeper enabling directions in ways that they're not designed to be used. And the Fair Work Act clearly says that an employee has a workplace right under those Jobkeeper enabling directions. So if your employer breaches your workplace rights by invalidly exercising those Jobkeeper enabling directions, again, an application to the Fair Work Commission can be made.
So just as a follow-up on that, is it your anticipation, or are you seeing that it's the smaller companies that are you're tending to see the problems, and is it because they just aren't aware of what their obligations are, or is it also some of the larger companies that know what their obligations are but aren't following them?
Look, it's predominantly amongst the smaller businesses, as you've suggested. I don't think in any of the cases I've seen, I don't think it's deliberate or malicious. I think it's a simple case of employers rushing to do things in the panic of the moment, and simply not dotting all their I's and crossing all their T's. There may well be businesses out there who are doing it deliberately or maliciously. Thankfully, I haven't seen any of that yet. But yes, it is largely amongst those small businesses who don't have a dedicated human resources team or a dedicated general counsel who's there to advise them about the process they have to follow.
Excellent.
Okay,
Thank you for that.
Thank you. Before I ask the next question, I'll just remind all the attendees out there, it's a fairly small group at the moment, so I'm happy to open the floor. Just use your raise hand icon and I'll unmute you. You can ask your question yourself if you have any. One of the questions I do have about working from home, I guess a lot of people don't have good setups for working from home. And I know you mentioned there's the option for, I guess, some of the bigger companies who have thought about things a little bit better, having tick box type scenario for, so you can actually assess your own work from home setup. In the event of someone actually spending a lot of time in their temporary or makeshift office and find themselves starting to get aches and pains or perhaps some long-term issues that result from that, where do employees stand with those kind of issues? Yeah,
an employee who suffers an injury in the home workspace like that would almost certainly be entitled to workers' compensation. I say almost certainly because there are circumstances where employees might have pre-existing injuries that render them, for whatever reason, ineligible, or that it might be, for whatever reason, a deliberately inflicted injury. But if it's just somebody who's sitting at their computer desk typing away and develops some sort of an overuse injury because their chair isn't, an ergonomic chair in their home workspace, then an employee would be entitled to make a workers' compensation claim in those circumstances. Hopefully, they would be proactive before it gets to that point, and tell their employer that, look, I'm using this chair that's really not doing anything great for my back or my neck or whatever it might be. And an employer who receives a request in those circumstances, as I said, has to do what's reasonably practicable to ensure the health and safety of their employees. So if it's reasonably practicable for them to have an office chair delivered from the office to the home workspace, that's arguably what they should be doing.
Okay, thanks very much, Lara. Is there any other questions out there? Doesn't look like we're getting any. I can't see any hands. Well, in that case, I'd like to thank you, Lara, for your time and for the excellent presentation you've given everyone. And hopefully our attendees enjoyed it as well. For those of you who may have come in late or missed part of it, we'll post this to the AIG YouTube channel shortly. I'd like to thank Lara once again, and hopefully, one last question, there we go, from Eric. Here we go. I was told not to take annual leave from a FIFO role due to COVID. After 2 weeks leave, I was then told my additional leave would need to be taken as the company was raising capital. I assume when all leave is used, the plan is to put me on leave without pay. Is this reasonable?
Sorry, you might have to repeat the question for me.
Can you see the Q&A panel? You might be able to see it, I think.
Hold on. Yep, I can. Okay, sorry. Look, it's very difficult for me to advise without knowing the background as to what's going on with the employer and as to what the employment contract and various other things say. But certainly it is pretty widespread for employers currently to be requiring employees to take annual leave. So my initial gut feeling is that there is probably a basis for the direction that they've given you. But I'd need to know a little bit more before I could provide definitive advice as to whether anything hinky is going on there.
Okay, thanks very much, Lara. We don't seem to have any other questions, so we'll leave it there. Thanks very much for your time, and I hope everyone enjoyed today's panel session.
Thank you.
Thank you.